Judge, just kind of, we cobbled our brief together pretty quickly, but I think I'm in favor in Guzman, you can't put a witness in front of the jury just for the purpose of having them vote. Both courts used a hearing outside the presence for that threshold determination. Past that, Judge, I don't really know what their intentions are vis-a-vis what they say wouldn't be covered. However, to the extent the entire exercise is so they can try and put impeachment evidence in front of the invoking witness, we cited Jackson versus State at 498 7th 2nd 906, Hernandez versus State at 31 7th 2nd 873 or 7th 3rd 873, and Ruff versus State at 31 7th 3rd 833. All of which stands for the proposition that you can't try and use the calling of a witness as subterfuge to put a document which is otherwise inadmissible in front of a jury. What happens, Judge, as we see it, is, again, subject to your threshold determination of the invocation, which we don't think, and this is where I was a little confused at the bench earlier, we don't think there's any question under favor in Guzman that inquiry has to be done in front of the jury. You don't go through this legal process in front of the jury. I don't know what they say they're going to put past that, but what happens to the declarant as to those issues as he becomes unavailable for purposes of 804, which at that point makes the deposition admissible for whatever purposes, and we go from there. I guess all of this is subject to their being Gawker's bigger point, that they think there are things outside of the areas in which the witness would invoke, which we have to go through that process with Mr. O'Brien, I think, anyway. So,
do you think that they're looking at the distinction between criminal and civil realm? Under the criminal realm, or in the criminal case, he pleads the fifth, and that's basically it for testimony, right?
most of the criminal cases have more of your blanket assertion type situations, yeah.
In a civil case.
But if I could, just one qualifier there, Judge, that's not to me particular, that could apply civilly. That's just how those cases seem to be factually, because there's usually just one issue. But go ahead.
But it seems that in a civil context, that's not necessarily so.
No, that's, the Guzman case is civil, and Guzman was a third-party witness, I believe, and as the court went through this process, they cited Favor, which is a criminal case, and essentially used the same standard. At Head Note 7, really the applicable language, in which the court stated the trial court permitted appellee over appellant's objection to call Christopher Broderick to the stand after appellee had informed the court the witness had indicated he would not testify. Once called, Broderick was asked by appellee if he had stolen the DC-4 aircraft from Cavaco's premises. As expected, he invoked the Fifth Amendment. Appellee's counsel then indicated he had no further questions. Appellants contended it was error to call Broderick to the stand for the sole purpose of having him claim his Fifth Amendment privilege. We agree. That's a civil case.
But that was the sole purpose, where there may be other purposes.
Well, and I think that's why I kept saying when we were up at sidebar before, and then of course, Judge, without reading all the language, of course, the danger of it is this: neither party gets a right to any input. Witness up there, and it just confuses the jury as to what the invocation does. So that takes, to me, the Fifth Amendment stuff out of play. That's why I kept referring to earlier the idea that once you make that threshold determination, that is, he doesn't invoke in front of the jury, if they have other reasons for which they want to call him, and they want to be candid about that, then I can respond as it relates to whether they're falling into those setting up their own impeachment cases, and it's just a subterfuge to try and get statements which may otherwise be hearsay in his impeachment. The other question becomes, Judge, at that point on rebuttal, because the declarant becomes unavailable at that point, whether we put his deposition on as an 804 declarant unavailable deposition in rebuttal. All of it springs off that initial issue, and so I think we need to hear from Gawker as to what they think is outside the Fifth Amendment realm, or from Mr. O'Brien, because he's really the one who's invoking.
But, and Mr. O'Brien's here, Mr. O'Brien's stated earlier, he's relatively new to this. So I don't know that Mr. O'Brien is actually seeing all of the different times that Mr. Clem has opened his mouth to this case.
But I think that the simple premise of that, Judge, is, and I think Mr. O'Brien made it clear earlier, he tried to ask the defense what they were going to get into so he could make a decision as to whether they would invoke. At some point, they have to talk about that.
But in all the cases, it says on a case by drawn adverse inferences should be considered on a case-by-case basis. And it all basically goes to trustworthiness and the search for truth.
And you get into issues like control, and if you're talking about Gawker factors and all that. Now, again, I don't think Florida, because that's an 11th Circuit case, the Florida cases, Guzman in particular, make it very clear it's reversible error to just let him go on the stand and invoke as to the areas that the court determines he can properly invoke. I don't think that what the defense is saying is that we're going to do that and ask him in those areas which the court identified earlier that may relate to, some of the bigger issues in the case, that we can make him do that. I think that Guzman makes that pretty clear it's reversible error to do it. The question then becomes, what else do they want to call him for? Can he invoke or will he invoke? And regardless of whether Mr. O'Brien knows a lot about this case, I think it's certainly his client's right to invoke where he sees fit. That's his call. It's his right. So we kind of do have to hear from him on that. Then, Judge, we had that sort of final argument, which is this just a subterfuge? Are they trying to figure out a way to get some paper in that they can't get in without trying to do this? So that's how I kind of see the issue's bigger picture.
So how, if you don't proffer outside the jury, how do I know, as the one that seems to have the discretion to make that decision, whether it is duplicative, the testimony is duplicative, harmless, or trustworthy, or as far as something that's totally outside the realm of his assertion of
That's a good question, Your Honor, and I think Mr. Turkel talked about a number of different things. I think your question touches on several.
My question really goes pretty much to the Coquina Investments case.
And that's where I was going to go. I mean, the way that I understand the state of the law is Guzman was decided in 1982 and was based on then existing federal law. In the intervening 24 years, there's been an evolution of Florida law, or there's been an evolution of federal law that has addressed the context of a non-party witness invoking the Fifth, and at what point can an party call that non-party witness to the stand. And this takes us to the case that Mr. Turkel mentioned that I think Your Honor was alluding to, the Coquina case from the 11th Circuit in 2014. And in that case, the court talks about 4 factors to look at and says that you can call a non-party witness to come to the stand, to invoke the privilege. And then it goes even further and says that there can be an adverse party drawn against one of the parties by that witness's invocation of the Fifth. And there's 4 factors that the court said that you look at, and I think that this is now accepted federal law. First, the nature of the relationship between the witness and the party.
Second, and I get that part, and I understand your argument on that. Your memo set that out really clearly. Here's the, I guess, my question. Then you get down to if you look at Coquina. Well, it's contained in, on page 13 of that, right above the notes 11 and 12. Here it goes into we adopt the 4-part test. And the bottom line, overarching concern is whether the adverse inference is trustworthy under all the circumstances. So play this out. This goes right directly to my question. He gets on the stand. Question is, did the plaintiff know whether or not he was being reported at the time? Which is the central question, I think, that he intends to fit on. And he says, I think he's it. Now, at that point, it seems to be the adverse inference is to the plaintiff.
Right, and we would just...
There's no evidence anywhere else that he knew anything that he did not know he was being recorded. The only thing that's contrary is Mr. Clem's radio show.
Well, that's not entirely true. I'm trying to think about what I can talk about. Mr. Clem's version of events is like a schoolyard seesaw. At one point, he comes on the air and says repeatedly on his own show and on the Howard Stern show that Mr. Balea was aware of the recording, he was aware of the tape, he was aware of the dissemination. They then settle the case. In that settlement agreement, as part of the terms of it, he says, I am going to say that you had no role in disseminating the tape, that you did have no knowledge of the taping. I'm not going to disparage you. I'm going to cooperate in pursuit of law. I'm also not going to disclose any information about you concerning your personal life or sexual life. And the case is dismissed without prejudice against him for $5,000. Because it's without prejudice, that guillotine hanging over his head if he doesn't comply with all of these things. He then goes and he issues a public apology saying the opposite, so we tilt back another way. He then goes on Howard Stern later and flips back the other way. He then shows up at the deposition where Mr. Balea and counsel are there, and he comes back the other way. In the interim, we know that he said other things an opposite way. Whether it's trustworthy or not, we would say that given the circumstances in the case, Mr. Balea has control over him, which is exactly the situation that it was in Kakina, and that the person in Kakina there was control over, had continued loyalty to, and he had agreed to cooperate during the internal investigation, and the court said that's sufficient. Just to be clear, we're not asking for an adverse inference here, but we do think that we have a right to question Mr. Clem about the nature of their relationship, the nature of the relationship between the plaintiff and Ms. Clem, who for her part, there's only 3 parties in this. The plaintiff, who we've already seen testify, we've seen like a hair of Ms. Clem's testimony, we'll see more, and part of what she says corroborates plaintiff's story, but she also testifies that the plaintiff is sitting at the table and she's intimidated testifying in front of him. I'm not sure what inferences to draw from any of this, but the jury has a right to test the credibility of all 3 of these people, who are the only ones who know what's going on. And frankly, we'd be extremely prejudiced to not have them here for all of these people.
But go back to the initial start of my question was, when we spoke about this morning, I recognize the fact that you would potentially should not have to give up your strategy, questions,
right,
part of it. However, how is the court supposed to make those, go back to my question just a minute ago, how is the court supposed to make those determinations unless you're operating it ahead of time? The determinations that are outlined, not necessarily the 4-part test, but all the other parts of it that the court is supposed to consider in their discretion under Kakina.
Now, in Kakina, as I recall, and I may be mistaken, as I'm sure Mr. Kirkell will remind me if I am, but I think the district court actually initially said that they would not find this testimony trustworthy, and then later after they said, oh, it turns out it was after the person got it.
Right, so I think that's pretty much what I'm saying.
Right, and to be perfectly candid, I have no idea whether Mr. Clem would be trustworthy. I don't know that anybody in the room would know that Mr. Clem is trustworthy on any of these stories. We don't know. But the only way to evaluate that is in the context of what he actually says. What we intend to ask him about is, 1, the nature of his relationship outside the context of this with the plaintiff. 2, the nature of his wife's, or his ex-wife's relationship with the plaintiff, which doesn't get to the fifth. And 3, there are numerous statements by the plaintiff and by Mr. Clem unrelated to this topic, but related to other issues in the case that they made on the radio and in other contexts that we should be permitted to ask him about. On things like, did the plaintiff know that he was being billed? Did he know that Mr. Clem burned the DVD? Did he know that he held the DVD? Did he know what Mr. Clem did with the DVD? I expect that he will take the fifth, and we do not intend to belabor that point, but we should be permitted to ask a series of questions in which he takes the fifth on.
In which case?
In which he does take the fifth on those points. But, I mean, that's what we're planning to do. I mean, I don't want to give away the farm. I'm happy to make some sort of profit to Your Honor, but I don't want to disclose to Plaintiffs' counsel or to Mr. Clem's counsel the precise nature of the question.
And I appreciate that It seems to me that Coquina tells me I need to hear the responses.
Or whether he'll vote, actually. not to cut him
In
off.
order to make those kinds of threshold issues, I mean, it's nice when there's an appellate court that can review it all later on. I'd like to try and get it right the first time around. So I don't know how to square that necessarily, though, with your right to put on your case however you want.
I don't.
Without telling me the preview.
No, I appreciate that, and I would like to put on the case that we want, but I think that in Coquina, the way that I understand these four factors is a prospective look, right? I mean, the nature of the relationship between the witness and the party. We know that these fellows have been long-time intimate friends. Second, the degree of control over the non-party. The settlement agreement gives them a leash around Mr. Clem's neck to say what they want him to. The compatibility of the interests of the party, directly aligned. Despite Mr. Clem saying he could both fit in these four walls, apparently on the airways around here, he's been going on at some length about the testimony and his own personal spin on it. And then fourth, the role of the non-party and the witness in the litigation. He's the central person in the case, next to Mr. Vallejo. And I just prospectively going in with those four factors, that's what the court is supposed to look at.
And the ultimate trustworthiness, which seems to be the overall, I mean, that's at the beginning of, it's the bookends, it's the beginning part of the test, it's the end part of the test, is the overall trustworthiness, and that's the...
Well, I take your point, Your Honor, and I mean, we are in a bit of a bind because Mr. Clem is a pathological, untrustworthy person.
I thought he was going to use the L word.
And from our position, we believe that the plaintiff, in all candor, has a reputation for dishonesty as well.
That's your position.
That is our
And
position.
he's a party, he's totally different.
You're right, but we're now stuck in a position saying, well, the plaintiff and his best friend, side by side, bosom buddies, he's a former best friend, are both, in our view, dishonest. There's no way that we're going to get trustworthy information, we believe, from either, but we should be able to allow the jury to come and hear what Mr. Clem has to say about the nature of their relationship, the nature of his ex-wife's relationship with the plaintiff, the things that he and plaintiff discussed on the radio, and then take the fifth of these limited number of questions.
Judge, I'm not going to use this. If
And
he's
now,
done...
Mr. Turpel and then Mr. O'Brien gets to close.
Judge, first of all, starting at Coquina only applies if they're seeking an inference. I mean, it says that at the beginning of Headnote 9. It says, mindful of this potential for inaccuracy and unfairness, other circuits have held that the admissibility of a non-party's invocation of the Fifth Amendment privilege against self-incrimination and the concomitant drawing of adverse inferences should be considered on a case-by-case basis. The whole premise of the Coquina factors is whether you're going to allow a jury to draw the inference. Because as all the Florida courts have said, it's dangerous when you put a witness up there who's a third party and they're invoking. I understand that there are citations to older federal cases in favor and Guzman. They're still the law in Florida. And you can't really right now say they're not binding precedent just because the 11th Circuit, which by the way was not relied on, it's not a Fifth Circuit case they relied on, it's a First Circuit case actually. I think U.S. v. Johnson is the one they cite. Has come out and it fits squarely into this strategic mess they've created. I take issue with this idea that the settlement was restricted to $5,000. There were copyrights in there and other things. Equally speaking, Your Honor, there is only one statement under oath at issue here, and that's the deposition. The radio banter he discussed, the radio apology, and the radio banter before the apology, were both available to preserve their rights at the deposition and were retracted under oath. And so they had a chance to confront the witness from the standpoint of this overall pitch that they've been deprived fairness. They confronted it. And honestly, from an evidentiary perspective, if you're looking for trustworthiness, the only piece of evidence that becomes admissible under 804 once he's available is the deposition, which is the only sworn statement we have. Now, going back to the overarching unreliability of it, I think Mr. Berry somewhat made my point. He just called the witness who he seeks to invoke and put in this position a pathological, untrustworthy person. I think we all know what he meant. The truth of the matter is, Judge, you have 3 or 4 statements at or around the time of this stuff happening. You have the demo in which all of them except one, which I won't mention on the open record, was not available at the time. You have a subsequent one, the TPD report, that is in public record, in which it lines up with the deposition testimony and the only statement under oath we have. And so you go back to where does that leave us? And I think it leaves us in 2 places. One, I think the court's still squarely bound by Guzman, and I just don't think there's any way we can make an argument that you should go to federal law, particularly when they've conceded that the factors they want to apply, they've conceded they don't want an inference when the factors that they want to apply only relate to the giving of the inference. And secondly, Judge, when you go to the overarching unfairness, the truth of the matter is, you know, maybe Mr. Berry's right. Maybe the argument he made does make sense in the sense that this is also untrustworthy, that you really can't put your imprimatur on it and get into this drill of the witness invoking when there's so many statements out there. All of it's subject to the fact that we are talking about a Fifth Amendment right, which, you know, I'm sure Mr. O'Brien and his client is extremely important. So that's kind of where we come down on this, Judge. I just don't think he can invoke on the stand at all. And then I think if they're going to call him, and Judge, I don't think you get it both ways. You can't come into the court and say, we don't want to proffer these questions on this constitutional right for strategic reasons. Trust this, Judge, it'll be okay. Because you have all the cases we cited that deal with whether they're using it as subterfuge to set up some other kind of impeachment or whatever. And we can't bet that argument if we don't know. So.
Thank you. Mr. O'Brien, would you want to another question for you?
Judge, I'll gladly cede my time to Mr. Berry if he would like to.
Mr. Berry, do you have a few things that you want to say?
I mean, I appreciate what Mr. O'Brien said. I might like to hear from him first, and then I may give you more.
Judge, as I said at the start of this hearing, took place this morning via sidebar, Mr. Clem and I have no dog in this fight. However, when it comes to my purpose for being here, it's to protect Mr. Clem's constitutional rights, and I intend to do so. With respect to the issue of certain areas that I've covered, both in my pleading and sidebar, I think that Guzman controls. The defendant is prohibited from asking these questions in front of the jury. In terms of any other innocuous question, something that does not involve a constitutional right, I attempted to find out what those questions were and try to avoid this to begin with, and I was unsuccessful. So here we are, and I still don't know what those topics are. I fear that we're going to create an even larger spectacle where I'm either sitting right there or even worse, up there, you know, whispering to my client or nodding to my client, no, yes, and it's going to turn into something that's unnecessary when we could simply do this outside the presence of a jury if this court is going to rule that this is a coquina factor matter versus a Guzman matter. I happen to agree with Mr. Turkel, not because I'm on the side of the plaintiff, simply because I believe that Guzman controls, and I think this is the way the court should rule. If the court has any other questions for me, I'd be glad to answer them.
Well, I guess I would extend or begin where Mr. O'Brien began. Mr. Clem does have a dog in this fight, and his name is Mr. Belay, and the settlement agreement that he found in the highway. And I take what Mr. O'Brien says about the Fifth Amendment. The fact of the matter is that Mr. Clem promised to cooperate with Mr. Belay to go after Gawker. And on the radio, he's been saying that he hopes that Mr. Belay collects substantial money from us. This whole ruse, we don't know what's real and what's fake here. And when Mr. Turkel says the only statements that he made under oath were at his deposition, I mean, as Your Honor knows, that's right as only as far as it goes about what statements here were under circumstances that should have been trustworthy. In that deposition, there are numerous statements that are demonstrably false that Mr. Clem made. And so to point to the one statement that Mr. Belay didn't know he was being filmed as the gospel at this point makes no sense. There's numerous other statements he made about all sorts of circumstances involving the tapes at issue, or the tape at issue here that are demonstrably false. And so in that deposition, he did say those things. I have no idea that they're true, and I would suggest that given the circumstances surrounding that that at the deposition, they were false. The bottom line for us is that this whole situation is incredibly prejudicial. The plaintiff has decided to go after us while settling with one person who apparently knows the truth. And now that person is not going to come in and testify as to those facts. And we cited cases in our paper saying that in parallel circumstances, courts dismiss these kinds of cases. If you can't get at the truth because of some implication of the privilege, you can't proceed. There's three people who know. Mr. Vallejo, Ms. Cole, who will tell you the story that she's going to tell you when we play her deposition, but will also say, I'm intimidated by this man sitting here. And then Mr. Clem, who's never going to hear this story.
So,
Just one point, Judge? Okay.
so, Mr. Beer, I'll want this to you. So, I am going to grant the motion to quash based on the untrustworthiness of this. However, I think that you should be entitled to proffer that testimony for the record outside the presence of the jury. Bring Mr. Clem in and ask him your questions so that you have that reserved one way or the other. But definitely outside the presence of the jury.
So the idea would be to preserve his testimony, but none of that would ever see the light of day. Or as far as this trial is concerned.
Judge,
I mean, I think that you have a right to preserve your record. No one knows what he would say one way or the other to your questions. That sort of goes back to my point that I started with in the beginning, is unless I heard it, how would I know? There's all those other factors that I'm supposed to consider in addition to the four-charge test.
Your Honor, at that point, if we were to do, I think this would be something akin to a videotape deposition.
Well, I would see me in the video. I'll prefer.
But I mean, at that point, once we have a record of what he says, would there be a possibility of playing that to the jury?
is that, if I may for clarification, is that assuming he doesn't invoke?
I imagine he wouldn't. You know, I don't know. I don't know what questions they intend to ask. I don't know what kind of responses he intends to give. So, but at that point in time, it would at least be preserved for somebody in court to say, yeah, Campbell did something wrong, or hooray for Campbell.
I think you have to do that, but the proffer. But the other point, Judge, and it was one point you didn't let me make at the end, was once he invokes, he is unavailable. The deposition at which they had confrontation rights becomes admissible under 804. They're not deprived of the right to designate. They had cross-examination rights there. They took the deposition. Equally speaking, the comment they made about Heather Cole, the party stipulated she'd appear by depo. So, you know, it's not like they were deprived of rights at the depo for the, quote, demonstrably false statements that they were confronting at the time.
Well, I think there were some aspects,
One
aspect, that became a big one for the defense.
It
was not available at the time of his deposition.
Nor was the TPD report that subsequently came out. There are other rules that may deal with that. And we can get to that if they choose to publish.
And I guess my only thought is, putting it on the bottom of page 5, justice and some other court will have to prevail on that one.
I have to see what you mean, Your Honor. Just on one point with respect to
People
this.
don't know how to zip it sometimes.
Footnote.
One page.
I'll take a look at that. I apologize, Your Honor. The one point to what Mr. Turkel said. We will make a decision, I guess, about whether to play Mr. Clem's deposition testimony. With respect to the confrontation, at the time that he was deposed, he was an available witness that would give you a discovery deposition. As I just mentioned, he made numerous false statements that he didn't.
We're on the way to another topic, right?
No, but I mean,
It doesn't go necessarily to the motion to quash.
It doesn't, but it does get to this point of how we can use, how we're going to handle this prejudice and whether he's unavailable and can use that deposition. It's a gamed, it's a great game at this point.
But I think both of you have to then drop back and decide how you want to proceed, and then you'll give me some motion on something, this is how you want to proceed, then, give you some kind of rule.
Thank you.
Right.
Yeah, no, that's exactly
I'm
right.
not
I didn't
telling you
learn
what's
that.
the next step. I'm just really simply on this one as, primarily on the trustworthiness aspect of it.
Thank you.
Okay. So, but I think that, and you're talking with Mr. O'Brien, you all need to, if you intend to, if you want to go down that other path outside the presence of the jury, and the defense needs to coordinate with that meeting.
Right. Well, we'll need to get together about the trial days over the next several days to see what would be possible.
Yeah, I think that's what's left, is they have to make a decision about proffer, and then we have to logistically discuss when we can do it.
And Mr. O'Brien can talk to his client about footnote 1 and file page 5 of the defendant's.
Okay. Are we going to get back in, or they want a short recess to deal with this?
Okay.
Yeah, just to be clear, on that point, we don't need to re-subpoena Mr. Flynn. I mean, he's under subpoena to come to whatever this sort of separate proffer will be.
Yes, that would, if the defense wants to pursue that, yes, we don't need to resubpoena him.
Yeah,
So that the subpoena is really for, or the ruling is primarily for testifying before the.
I think, would it be fair to say,
Mr. O'Brien is
the
telling.
trial subpoena is quashed, but he has been ordered with his counsel here to appear for a proffer. Is that fair?
That would be a fair statement.
That makes
Mr. Berry,
sense.
did you hear that? So he said that the trial subpoena would be quashed, but to appear before with his counsel for the proffer would be still.
Yeah.
Okay,
He's
thank you.
otherwise ordered by the court to make himself available for the proffer.
Yes.
Okay.
Mr.
Understood.
O'Brien, you understand? Okay. Thank you, Mr. O'Brien, for coming back.
Anything excused, Your Honor?
Thank you. Okay. Anyone need to break the rule and continue? Mr. DeLario?
Oh, he's not in here.
Oh, okay.
Wait, kept him in a secure location.
Okay. So why don't we take just a brief break, bring Mr. DeLario back and bring in the jury.
Thank you.
Thank you.
Is to
Late lunches and breaks.
The jury is in your box to see.
Thank you, everyone, to be seated. And so, members of the jury, thank you for your patience. I know sometimes I say a 10-minute break, it goes a little longer. Trust me that we're also doing other things that are in here that aren't appropriate for the jury. So I apologize sometimes for being a little bit late on lunches and breaks. It's sometimes how it works. So where we left off before the lunch break was Mr. Valerio was answering questions for the plaintiff. The plaintiff is finished with the cross-examination. Now we're going back to redirect.
yes, ma'am. Thank you, Your Honor. Mr. Delario, I want to clear up just a couple quick things. You will recall before the lunch and recess, you were pointed to your deposition and you were asked about dealings with Mr. Burton. You remember that?
Yes.
Okay. Let's look at the complete passage there. If you would be so kind as to turn to page 140 of your deposition.
Okay.
Do you have page 140 there?
I do.
Okay. And look, starting at line 7, you'll see question. Okay, did Gawker Media, to the best of your knowledge, have any previous dealings with Mr. Burton? Answer, not to my knowledge. Question, okay, you had specifically yourself? Answer, I couldn't remember exactly where and what point we had interacted. Question, but this was not the first you had heard of him? Answer, no, but just in email. Question, okay, had he ever been a source for you of any other material? Answer, I don't think so. Question, okay, did anyone else at the Don Buchwald Agency ever serve as a source for Gawker Media? Answer, I don't think so. Did you see that?
Yes.
And was that the complete series of questions that you were asked about this business with Mr. Burton?
Yes.
In terms of prior deal?
Yes.
Okay. If you now would look over on page 159,
Okay.
and direct your attention to line 8. This is the part where you were questioned about, did you think the Hulk Hogan piece would be popular? And that passage. Are you focused on that?
Yes.
Okay. Look at line 8. Question. Did you believe that publishing the video would generate traffic to the site? Answer. I believe that it would be somewhat popular, yes. Question. Was it? Answer. Eventually. Question. I'm sorry, your answer eventually? Answer. Eventually, yes. Question. Why do you say eventually? Answer. Because initially, I don't think it was one of the top stories on the site, and I was curious as to actually why that was the case, and then it became a lot more popular a couple days afterwards. Question. Do you know what caused that? Answer. I believe it became national news at that point, and Hulk Hogan was doing a very good job promoting it. Did you see that?
Yes.
Is that the context in which that earlier question that was posed to you was placed?
Not exactly.
That is your complete set of answers there?
Yes.
Okay, fair enough. All right, Your Honor, I have no further questions at this time.
All right, thank you. Have any questions? personally from posting of the video, such as reputation, promotions, etc.?
Outside of this? Or,
So the question is just how did you benefit professionally and personally from posting the video?
there was really no direct impact.
Any follow-up to that, Mr. Spencer?
Not for me. No, Your Honor.
No, Your Honor.
All right. How do you define any obligation that you have to individual privacy?
It's a story-by-story basis.
Any follow-up? Mr. Spencer?
No, ma'am.
Mr. Burton?
No, Your Honor.
What sites did other sex tape links in your article go to?
They were screen grab sites, I believe, and I'm not really sure offhand, but I can check.
Yes, just very briefly, so as to avoid confusion. Mr. Galerio, when we walk through the little red linked things that we walked through, the one went to Pamela Anderson's sex tape, the one went to, right?
Right.
Those weren't actually going to the sex tape. They were going to stills from the sex tape.
That's correct.
Okay. Purpose being to remind your readers of those
Yes.
sex tapes.
Just to clarify, those links were from other sex tapes, correct?
There were pictures of either the box or at least images from the sex tape, yeah.
Other celebrity sex tapes?
Other celebrity sex tapes.
Sex tapes that were sold?
Yes.
No questions.
Thank you.
And why didn't you write an article on sex tapes before with sold sex tapes that were available?
Specifically about that topic?
Yes.
No reason.
Mr. Sullivan?
No, ma'am.
Mr. Bowman?
No, Your Honor.
And I know there were other juror questions that were involved in that that would not be appropriate for this witness to answer. Any other juror questions? All right, then, Mr. Lewis, you can sit down.
Thank you. Thank you.
Your Honor, the defendants call Emma Carmichael. She's not. She has to.
Now, you can step this way, please. We can stand here and face the clerk, waiting for your
You solemnly swear affirm the testimony given in this case to the truth, whole truth, and nothing but the truth, so help you God.
Thank you. Step over here. Watch your step, have a seat, speaking aloud, clear voice for the court.
Thank you, Your Honor. Good afternoon, Ms. Carmichael.
Good afternoon.
Would you please state your full name for the court?
Emma Carmichael.
All right. Now, where do you presently work?
Gawker Media.
And you work in its New York office?
I do.
Okay. How long have you worked for Gawker?
I've worked on and off for about 5 years for Gawker.
All right. And where did you go to college?
At Vassar College.
And after leaving Vassar, I assume you graduated?
Yes.
Okay. After leaving Vassar, was your first job at Gawker?
No, my first job was with the New York City Parks and Recreation Department.
Okay. Let's go back just one more step. Where'd you grow up?
I grew up in Brattleboro, Vermont.
Okay. And what was the year in which you graduated?
2010.
Okay. So then you go to New York Parks and Recreation?
Yeah, that's right.
And about how long did you hold that position?
About 5 months. I was a public affairs officer.
Okay. And what was your first connection with Gawker?
I worked as an intern for Deadspin during that same period, and I covered nights, so I would cover sporting events and post stories to the site.
Okay. So you'd work for Parks and Rec during the day, and then you would work at Gawker in the evenings?
That's right.
Okay. Now, so you started Deadspin. What is the focus of Deadspin?
I'd say sports and sports media and sometimes sports gossip.
All right. What is your current position at Gawker?
I'm currently editor-in-chief of Jezebel.
Okay. And Jezebel, could you explain to folks what Jezebel is?
Yeah, Jezebel is loosely a site for women. We cover women's issues. We have a mostly female staff, and we write to a mostly female audience.
Okay. How long have you been editor of Jezebel?
About a year and a half.
Now, between when you worked at Deadspin, how long did you work there?
Well, after I was an intern, I was hired in January 2011 as a video editor and staff writer, and I held that position for about a year.
Okay. And Deadspin, what different positions did you hold?
I was hired as a video editor, and I was promoted, or my title changed to staff writer a ways in, and I later returned as managing editor.
Okay. All right. Then, and you explained to us, you're presently the editor-in-chief at Jezebel. What other positions have you held at Gawker?
I was managing editor of Gawker.com.
Okay. And what point in time did you serve as managing editor of Gawker.com?
It was the period, I started that position when AJ took over as editor-in-chief. So I started in January 2012, and I held the position for a year.
All right. After that, after you held that position for a year, where did you go after that?
I briefly returned to Deadspin, and I was managing editor there. And then I ended up taking a job at a different website, a different company called The Hairpin.
Okay. And what did you do at the Hairpin?
I was editor-in-chief of the site. It's kind of a smaller women's site, so I published and edited just about everything we put on the site.
Okay. So you worked at the Hairpin. At some point then, what did you do after working at the Hairpin?
I returned to Gawker Media. I took the editor-in-chief job at Jezebel.
Okay. All right. Now, when you worked at Deadspin, who did you report to, or who did you work for?
AJ Delario.
Okay. And when you became managing editor at Gawker.com, who did you report to?
AJ Delario.
Okay. And did you leave Deadspin and come to Gawker.com at whose behest?
Yeah, AJ invited me to be managing editor after he took the editor-in-chief job there.
Okay. So at this point in time, did you like working with AJ?
I did, yeah. I felt I had learned a lot from him at Deadspin, and I felt eager to keep working with him at Gawker.
Okay. I take it if that were not the case, you would not have gone to Gawker.com to work with AJ.
That's correct.
Okay. All right. Now, when you were managing editor of Gawker.com, could you please explain to folks what your duties, what your responsibilities were?
Yeah, I basically oversaw our site management day to day. So that meant assigning and developing stories with our staff writers, and also just working very closely with our staff writers to get them on their best work and develop, feature ideas with them that we'd work on, beyond just our usual day-to-day news blogging. And I also did kind of site maintenance and management.
All right. When you refer to site management, what does that entail?
It's basically making sure that we're, staying up with the news cycle, that we're not missing out on stories that we should be covering. Sometimes it means, copy editing or tweaking headlines, or working with writers for a specific angle they might bring to a story.
Okay. And you mentioned feature development. Is that kind of a little beyond just the day-to-day, what story's going to appear on the Post this afternoon?
Yeah, we wanted our writers to be working on their best work. So we'd have them working on longer projects, or sometimes they'd go out on reporting trips, and they'd be, turning around eventually drafts of stories, what we call features, so feature stories that we'd go back and forth with edits on. Maybe we'd get an original illustration for it, and we'd work on like the story layout together.
Okay. And then you mentioned story assignments. Is that kind of pretty much what it sounds like?
More or less, yeah. I think it requires kind of knowing what your staff is best at, but figuring out what their strengths are and what news stories they'd be best to cover.
Okay. So like in any other job, you try to figure out who you got, what their skills are, and you assign them so they can do their best work. Is that fair to say?
Yeah, I'd say so.
Okay. Were you good at that?
I was good at it. I was quite young for my job, and it was a pretty high-pressure job that I kind of learned a lot on the ground.
Okay. Now, how would you said I was young at the time. From where I sit, you're still young. But, that's a whole other story. How would you describe the experience going from being a Deadspin staffer, so then you get promoted and you end up the managing editor for Gawker.com as a fairly young person, right? How would you describe that experience to people?
It was, like coming into any new job, it was a bit overwhelming at first, and I had my own anxieties about how I'd rise to the occasion. But I also had been doing a bit of that work at Deadspin, because we had a pretty small staff, and the way our days flowed, I ended up doing a bit of informal managing and editing anyway. So I felt prepared for the general work requirements, and I also knew that I'd have to learn on my feet and kind of figure out how to best serve the staff and be a resource to them. And that was stressful like any other job, but I felt really prepared for it and ready for it.
Okay. So you felt ready at the time to take on that additional responsibility. Is that fair?
I did, yeah.
Okay. Now, Gawker.com at the time, how big was the staff?
I think it was about 10 people.
10 writers?
10 including editors, I think, maybe a little bit more.
All right. And now, so you've got these folks, how many, just approximately, how many posts would you be producing a week?
In a week, it's hard to say, anywhere from maybe 100 to 200 posts in a week.
Okay. So it varied?
Yeah, I'd say so.
All right. Now, did Gawker provide you with training, any particular training for that job as managing editor?
I wouldn't call it particular training. I think, as with many jobs in journalism, I learned best in the field and working. And I had, a number of conversations with AJ about the job and what it would entail and how he thought I could best serve our staff. But I wouldn't call it a formal training.
Okay. So would it be fair to say that what we're talking about in journalism is kind of on-the-job training?
Yeah, I think, some people opt to go for an advanced degree or for formal training. I did not, and I thought I'd be best served going right into work and learning in the field, as I said.
Okay. As an editor that you reported to, was AJ good about giving you time when you needed to discuss a matter or confronted a situation you'd not dealt with before?
Yeah, absolutely. We might have kind of informal conversations about a certain staff writer, how we could best work with her or him, what kind of stories we should get them working on.
Okay. You worked with AJ, I think, roughly how long altogether?
About 2 years.
Okay. And what lessons did you learn from Mr. Delario?
I learned a lot from him. I'd say probably the two most valuable lessons I learned from him is just good management. He's very good at getting the best work out of his employees and motivating them to do their best work. And I also learned, I think, about going after good stories and publishing them and putting together like the most complete site we could every day.
Right. Was he good at recognizing talent?
Yes.
Was he skillful in matching this person's talents with a particular story or assignment?
Yes, I'd say that's one of his great talents.
Okay. And did you learn from him in those respects?
I did, yeah.
All right. How would you describe, if we were to talk about your professional relationship with Mr. Delario, how would you describe it in your own words?
I'd say we're good friends and that he's been a mentor to me in my career.
Okay. Would you say he's been a mentor? Has he helped you in your professional development as a journalist?
Yeah, absolutely.
Okay. What do you think, you've worked with him for about 2.5 years, what do you think about his talents as a journalist?
I think he's a wonderful journalist and a great manager.
All right. What is your professional relationship with Nick Denton?
It's a good relationship. It's been cordial, and we've worked, on and off together for 5 years now.
All right. I take it you haven't worked as closely with Mr. Denton as you have with Mr. Delario.
That's right.
Okay. Now, let us shift our focus, and we're going to talk a little bit about the post which brings us here today. Are you familiar with the October 2012 post written by Mr. Delario that is the subject of this case?
Yes.
Okay. Are you familiar with the video excerpt that accompanied that post?
Yes.
All right. When the piece and the video excerpt were posted on Gawker.com in October 2012, what was your position at that time?
I was managing editor of Gawker.com.
Okay. Did you play a part in the publication of the video excerpt?
Yes.
All right. What part did you play in the publication of the post?
Well, I copy edited the post, which essentially means I read it for spelling and grammar errors and for basic sentence structure fixes. And I also communicated with our video editor to communicate, AJ's request for how we would edit the video.
All right. Let us go back to the time when the video material, the so-called Hulk Hogan sex tape, first arrived at Gawker. All right. You focused on that period.
Yes.
Okay. What role did you have in receiving that video, the so-called sex tape?
Well, AJ was out of town, and I had received some kind of message from him that a package was arriving that would contain, a DVD or some kind of file that had this on it, and it arrived to his desk when he was out of town. And he had instructed me to open it and play it, so I did.
Okay. So he was out of town, he gave you a heads up so you could be on the lookout for it?
Yes.
Okay. Now, when it arrived, what did you do? What did you do next?
I opened the case and I took out the DVD and I played it briefly on my desktop computer.
Okay. So you watched portions of the video?
Yeah, I watched a brief portion of it that day.
All right. And after you looked at the video, did you tell Mr. Delario anything about it?
I just told him that we had received what he thought we were going to receive, and I waited to hear more from him for how we'd pursue.
Okay. So you told him it was as had been foretold, right?
Yes.
Okay. So did he tell you who sent this video, this Hulk Hogan sex tape, to Gawker?
No.
To this day, as you sit here with us, do you know who sent the tape to Gawker?
No.
You know who sent the tape to Mr. Delario?
No.
Now, you view it, you confirm to AJ that it had shown up, right? What happened? What did you do after that exchange with Mr. Delario?
I believe I mentioned to our to Leah Beckman, who was another editor with us, that we had received this, and I was waiting, word or AJ's return. And then I kind of went on with my day, so I had a site to run.
Okay. Was any guidance provided about where this, I take it Mr. Delario returned at some point?
Yes.
Approximately how long after you had done the initial brief look at the video?
Approximately within a week of that time, yeah.
So he's now back in the office. Was any guidance provided about where this particular piece was headed?
Yeah, I kind of had a loose understanding of the piece he was working on, and that there would be, commentary, and that we would edit down the video into a very brief portion.
Okay. Did you say a brief portion?
Yes.
And was it Mr. Delario who provided that guidance?
Yes.
Okay. Now, what direction was provided about editing the video?
Well, we kind of wanted it to go along with the commentary that AJ was writing, and so we wanted a minimal amount of sex in the actual video, and we wanted kind of an abundance of kind of general, daily conversation that we ended up highlighting in the video.
Okay. And was that direction provided by Mr. Delario?
Yes.
Okay. All right. What about subtitles? Was there any decision to include subtitles?
I can't recall.
Okay. Now, you as managing editor, I take it you didn't do the actual film editing?
No, I did not.
Okay. And who handled the actual film editing?
Our staff video editor, Kate Bennett, did the editing.
Okay. Did you speak to her about editing the video?
Yeah, we communicated a little bit in the office, and I just passed on AJ's request for the edits.
Okay. So you gave her direction about how Mr. Delario was intending to frame this story?
That's right.
Okay. And did you speak together with Mr. Delario and Ms. Bennett, or did you deal with her separately?
We might have all spoken together. I don't recall exactly.
Okay. So before this piece is published, you've spoken with Mr. Delario, Ms. Bennett, about the editing?
Right.
Okay. Did you see the edited version of the video excerpt before it was actually posted?
I'm not sure. I believe I did.
Okay. Now, you've seen that video excerpt?
Yes.
Okay. The portion that was posted on the site. How would you describe the quality of that video itself?
It's not very good.
And when you say not very good, are you speaking in terms of the quality of the actual video product?
The visuals,
yeah.
Correct, yeah. Yeah, it's in black and white and kind of grainy from what I remember.
Okay, all right. Now, did you read the post, the actual commentary, before it was published on the site?
I did, yes.
Okay. And did you perform an editing function on the post itself?
Yeah, as I said, I did a copy edit, so I checked for spelling and grammar errors and that sort of thing.
Okay. As the managing editor for Gawker.com at that point in time, what did you think about the final version of the piece with the video excerpts?
I thought it was complete. I thought we provided, sufficient context for the story that we were reporting on, a story that had been reported on, and I thought that AJ's tone and his commentary aligned with the video that we were actually publishing, and so we were presenting kind of a clear piece with an argument that was reflected in both the video and the commentary.
Okay. Were you comfortable with the post when it was published on the site?
Yes, I was.
Okay. How long was the video excerpt?
I believe it was under 2 minutes.
Okay. And as you sit here with us today, do you remember how much of it was actual depicted sexual activity?
Yeah, I believe it was under 10 seconds depicted sexual activity.
Okay. As managing editor, were you comfortable with the way the story was framed?
Yes, I was.
As managing editor, were you comfortable with the context that was provided with that story?
Yes.
All right. Ms. Carmichael, what does this, we've seen the piece, we've looked at it, the NSFW stand for?
Not safe for work.
Okay. And what does that mean to you?
As someone who uses the internet every day, it's sort of a good warning signal that this might not be something that you want open in your place of work.
All right. Now, let's take a look at, Tim, if we could pull up Plaintiffs Exhibit number 2, which is the, you'll see there, that is the October 4, 2012 post. Do you recognize that?
Yes.
Okay. Now, did you see the headline, even for a minute, watching Hulk Hogan have sex in a canopy bed is not safe for work, but watch it anyway. Did you see that?
Yes.
Okay. Did you have any role in writing that headline?
No, I didn't.
Is managing editor, so Mr. Delario wrote the headline?
I believe so.
Okay. And as managing editor, were you comfortable with that headline?
Yeah, I thought, and I still think that it reflected the kind of tongue-in-cheek tone of the post itself.
Okay. So you took it in kind of a tongue-in-cheek context?
Yes.
All right. Now, at the time you were working on this particular post, did Mr. Delario indicate his expectations regarding the level of traffic for this story?
No, not that I can recall.
Okay. Did Mr. Delario indicate what he thought of Hulk Hogan?
No.
Okay. While working together on this story, did Mr. Delario indicate in any way that he harbored ill will towards Hulk Hogan?
No, not at all.
Now, is the managing editor, the news value, what did you take the news value of Mr. Delario's piece in the accompanying video? Did you think it was newsworthy?
I did, yeah. I thought it was dealing with a public figure, and it was a story that had been previously reported on for months at that point. And once we had the document itself, we felt we had the right to move forward with publishing it.
Okay. And were you concerned, as the managing editor, were you concerned about Gawker relying on material that had been provided by an anonymous source?
I think normally that would be a concern, certainly. I think in this case, the document we'd received in the mail was essentially self-authenticating, and by that I mean it was exactly what we were told it would be, and we were comfortable with that.
Just so we're clear, when you say the document you received in the mail, you're referring to the sex tape?
Yes.
Okay. You're using documented kind of broadly?
Yes.
Okay. And then, when you refer to it being self-authenticating, could you explain to folks what you mean by that?
Yeah, the person in the video appeared to be who we were told it would be, and the screenshots that had been previously published matched the video that we'd received in the mail.
Okay. When you viewed portions of the tape, did you think the tape was made without plaintiff's knowledge?
I didn't know.
Okay. You couldn't tell for certain?
No, I couldn't tell.
All right. What impact did that have on your decision, Gawker's decision, to publish excerpts from the sex tape?
We considered it, but we also felt like the context surrounding the story, the number of stories that had already been published on it, and the context we gave it in the actual published piece were sufficient.
All right. Let me ask you this. Did you consider that Hulk Hogan might be upset by the publication of these excerpts?
Yeah, I did.
All right. And if you could explain to us like how you grappled with that in your position there as a journalist.
Yeah, I think it's something journalists grapple with frequently, maybe regularly on a day-to-day basis, you consider the stories that you're publishing and how they might affect the subjects that you're writing about. It's also true that when you're writing about public figures, you're not often or constantly writing kind of glowing profiles of them. And it's true that in this case, we knew we weren't doing that either. And those are considerations you make, and if you feel like you have the full story, correct story, and you feel comfortable with what you put together, you make the decision to publish.
Do you personally find that to be difficult at times?
Yeah, I do.
All right. Now, you left Gawker.com to go back over to Deadspin shortly after the Hulk Hogan post.
Yes.
Is that right? Roughly how long between the post in October and when you went back to Deadspin?
Roughly three months, I'd say.
Okay. And did Mr. Delario leave Gawker.com about the same time?
Yes.
Okay. Was your departure in any way related to the publication of the challenge post?
No, it was not.
Not at all?
Not at all.
Okay. And to your knowledge, was Mr. Delario's departure, was that related in any way to the publication of the challenge post?
No, it was not.
Right? Okay. Thank you very much.
Thank you.
Thank you, Your Honor. Good afternoon.
Good afternoon.
You testified that in late 2010, for about 3 months, you were an unpaid part-time intern at Deadspin.
About 5 months, I believe.
And as an intern, you worked the night shift.
Yes.
And then in January 2011, A.J. Delario offered you a full-time job at Deadspin as a video editor.
Yes, that's correct.
And all this happened right after you graduated college, correct?
Yeah, that's correct.
You had that job for 1 year, the video editor job, which also included writing stories.
Yes.
And you reported to A.J. Delario throughout that year?
Yes.
And then after that year, A.J. Delario promoted you to be managing editor of Gawker.com?
Yes.
And that was the #2 position at Gawker.com?
That's correct.
And you were 23 years old at the time?
That's correct.
And you had only been in the working world for 1.5 years, correct?
Yes.
You received no formal training before you became managing editor of Gawker.com?
I wouldn't say formal training. As I said, I think I received informal training, conversations with AJ about the work that I'd be doing, the staff I'd be overseeing, and how I could best fill that role.
My question is, you received no formal training to be editor, managing editor, correct?
That's correct.
Your only training was on the job?
Yes, as in many fields, I learned on the job.
When you and A.J. Delario were at Gawker.com, Mr. Delario, as editor-in-chief, talked with staff about the need to drive as much web traffic as possible to Gawker.com, correct?
Yes.
And the 1 and 41-second sex video drove millions of people to the Gawker.com sex tape page?
Yes.
And when Gawker Media sites have more web traffic, Gawker Media makes more money from the advertising?
I think that's loosely correct, yes.
Could we pull up Plaintiffs Exhibit 114, please? Go to page 2. We're going to blow this up. You can see it on your screen. You've seen this document before?
Yes.
These were emails that were received by all 10 editors and staff writers at Gawker.com in March 2012, correct?
Yes.
And you received these emails yourself?
I did.
And these emails state, quote, Hulk Hogan says the sex tape being shopped to porn companies was secretly filmed without his permission. And then the line below that, and is nothing less than an outrageous invasion of privacy. Do you see that?
I do.
And these emails were received by everyone at Gawker.com on the editorial side, all 10 people 6 months before, your office received that DVD, correct?
Yeah, I can't speak to how many people read this particular email, but if it was sent to tips, then everyone received it in their inbox.
That was my question. It was received by all 10 people?
Yes.
6 months before you received the DVD that had the Hulk Hogan sex tape on it?
Yes.
You testified a moment ago that you could not tell if Mr. Balea was secretly filmed
That's correct.
from watching the video. But you watched that video, or portions of it, and you saw that the camera was from a very high point of view,
Yes, I did.
and the camera was far away from the bed,
Yes.
and Mr. Balea never looked at the camera,
In the portions that I saw, no, he did not.
and the woman never looked at the camera.
That's correct.
You're aware that this lawsuit was filed October 15th, 2012?
Yes.
We pull up Plaintiffs Exhibit 126, please. You've seen this document before?
Yes.
The date of this document, it's an email exchange, and it's a few emails, October 22 and October 23 of 2012. Do you see that?
Yes.
So these emails were 1 week after Mr. Balea filed this lawsuit.
Yes.
This was an exchange between you and AJ Delario about editing a second Hulk Hogan sex tape to be posted at Gawker.com, correct?
Yes.
1 week after this lawsuit was filed.
That's correct.
And at the bottom, Kate Bennett, who's the video editor, who edited the original minute and 41 tape, is sending to you this second Hulk Hogan sex tape, correct?
Right.
And this was edited from the original 30-minute DVD that you received in the office?
Yes.
And so Kate is telling you, okay, so here is this, and then there's a link, and then you went to that link and you watched all or a part of the second Hulk Hogan sex tape?
Yes, to the best of my recollection.
And then she asked you if it's good to go, I can subtitle it tonight or whenever. And then above, you respond, you wrote to AJ Delario, this work, subtitles, question mark?
Yes.
So you were asking Mr. Delario if this was acceptable to post and if he wanted to have subtitles on the second Hulk Hogan tape?
I don't think I was asking if it was acceptable to post, but I know that he was working on a second story, and we were trying to put a video together for that, so I was asking if it was what he wanted out of the second video.
And then Mr. Delario responded, subtitles maybe. He was sending this to you. Subtitles maybe. Also, is there any more ridiculous sexy talk a la Bubba effed the SH out of me today, correct?
Yes.
And then below that he says, but it's headed in the right direction.
I see that.
You're familiar with revenge porn?
Yes.
Your definition, which you gave at your deposition, is that revenge porn is when a pornographic video or photo is used to punish someone?
Yeah, that's a pretty broad definition that I gave, and I think that the term has evolved quite a bit over the years.
But that's the term you gave at your deposition?
Yes.
And you had an opportunity, did you not, to write out any changes that you wanted to within 30 days of receiving your deposition?
Yes, I did.
And you never changed the definition of revenge porn?
No, I didn't.
And I asked you at your deposition, how is porn used to punish somebody? And you answered, quote, tapes recorded against someone's will or released against someone's will. Correct?
Yes.
At the time Gawker posted the Balea sex video, you had no idea if the video was sent by somebody who was engaged in revenge porn.
No, I didn't.
And you are not aware of any effort by anyone at Gawker.com to find out if the Balea sex video was revenge porn.
No, I'm not.
You were the managing editor of the site, the number 2 person, and you made no effort whatsoever to find out if the Hulk Hogan sex video was someone committing revenge porn?
No.
It was assumed at Gawker.com that Mr. Balea did not approve the release of the sex video, correct?
I believe so, yes.
Let's pull up Exhibit 70, please. This is a post at Jezebel from July of 2014.
Yes.
Were you the editor-in-chief at Jezebel at that time?
No, I was not.
Are you familiar with this post?
Yes.
It's titled, "Tumblr Refuses to Take Down Illegal Public Restroom Photos." Is it your understanding that, well, let me ask a different question. Do you know the person who wrote this?
I've never worked directly with her, but I know her byline.
So let's blow up the first paragraph there, please. This is somebody at Jezebel who was criticizing the fact that Tumblr was not removing a secret bathroom photo from Tumblr, correct?
Yes.
It says former police officer David Cerno was recently arrested for placing a hidden camera in a mobile gas station bathroom in Chesterfield, Missouri, and then posting the videos on a porn site. Now, after the site has been taken down, stills remain searchable on Tumblr, yet Tumblr refuses to take down the photos. What gives? Question mark. Apparently, Tumblr is loath to honor potential victims' requests. Correct?
Yes, I see that.
And then if you can turn the next page, please. The highlighted part. To Tumblr, just above the yellow. To Tumblr, how about taking down the photos because they're clearly a violation of people's privacy? As of the date of your deposition, you testified you had spoken to Nick Denton between 50 and 75 times?
Yes.
Is it your understanding that Mr. Denton believes that journalism should include exposing people's secrets?
Sometimes.
And it's your understanding that Mr. Denton believes that playing video of people fully naked is part of journalism?
In this case, it was.
And it's your understanding that Mr. Denton believes that journalism should include playing video of people having sex?
In this case, it was, again.
Even if the subject of the video does not know that they're being recorded, that is still the case?
In this case, it was, or we assumed it to be.
You are aware that Mr. Balea was likely to feel distressed, hurt, upset, and embarrassed, and yet Gawker.com posted the sex video of him anyway, correct?
Yes, I put thought into that.
And you believe it was a good thing that the video of Mr. Balea fully naked and having sex was posted at Gawker.com, correct?
I believe that the video edit that we published and the commentary that accompanied it was a full and complete story, yes.
That wasn't my question. My question was, do you believe it was a good thing that Gawker.com posted a video of my client fully naked and having sex?
Yes, I'm comfortable with the story that we published.
And if you had it to go over again, you would do the same thing?
As I believe I said in my deposition, that if history were to repeat itself, I would republish the story.
No further questions.
Thank you, Your Honor.
Ms. Carmichael, just to clear up a few points. Mr. Harder called up an email that you received from TMZ. Do you recall that?
Just seeing it now, yes.
Yeah. He called up an email and it had a quote in there about secretly filmed or some such thing. These emails, who did they come from?
I believe that was from TMZ's publicist.
Okay. So aren't they like called TMZ tips? Isn't that what they...
Yeah, that's correct. Yeah.
All right. Now, do you get these, this isn't some kind of legal notice, is it?
No.
No. It's a publisher, TMZ, who we've discussed here before you arrived, is into this whole celebrity, gossip, all this kind of stuff. That's kind of their stock and trade. Are you aware of that?
Yes.
Okay. Now, they send these so-called advisories, they send these tips to let you know at Gawker that they did a story on something.
Yes.
Is that fair to say?
Yeah, we receive a number of those in a given day.
Okay. Is their purpose to draw attention to what they're putting out there?
Yeah.
Okay. And I take it, do you read every one of these TMZ tips religiously?
No, I don't.
Do you read them on a regular basis?
No, I don't.
Okay. I assume that in your role as managing editor, you receive all manner of things, right?
Yes, our tips line is quite active.
Okay. People are hoping, I take it, that you at Gawker will pick up on their story and that'll bring more attention to them, right?
Yeah, that's correct.
Okay. Is that customary in the online publishing business based on your experience?
Absolutely.
Okay. Now, Mr. Harder talked with you about a second story, right?
Yes.
A potential second story on the Hulk Hogan sex tape. Okay. Did such a second story ever run?
No.
All right. Never saw the light of day?
No.
Okay. Mr. Harder also talked with you about revenge porn, right?
Right.
Is revenge porn a subject that you, when you took over the site at Jezebel, something that you have reported on?
Not me personally, but the site has.
Yes.
Yes.
Pardon me. The site when it was under your editorship?
Yes, that's correct.
Okay. The Hulk Hogan sex tape post appeared back in October of 2012. Was this notion of revenge porn, was that big in the public consciousness at the time?
No, not very big. I'd say it had a much more kind of a smaller definition at the time.
All right. What was the definition, at least as you understand it, at that time, back in the fall of 2012?
As I understood it, it was specifically kind of relationship focused. So the idea was, adults who were in a consensual relationship who might have shared naked videos or photos or filmed themselves having sex. After a breakup, one of them would use those documents to, publicly shame or punish their former partner.
Okay. So someone is hurt or frustrated by the breakup of the relationship, and then they take private information, put it out there to embarrass a person?
Yes, that's correct.
Okay. And I take it these are private individuals?
Yes.
Okay. These aren't celebrities, these aren't rock stars, that kind of thing?
No.
Okay. And that was of concern to people?
I'm sorry?
And that became a concern that was addressed?
Yeah, there were a number of sites at the time that were specifically created to cater to that, to people who wanted to do that, and that was a big topic of discussion on the internet.
All right. And just to, I think you'll recall that the piece that Mr. Harder displayed there on the screen bore a date not of October 2012, but 2014, right?
Yes, yeah.
Let me ask you this last thing. Did this whole notion of revenge porn and the concern about it, has it only grown in recent years?
Yes.
Okay. And presently, as we're here in 2016, it's an even bigger issue?
Yes, it encompasses a much bigger realm, I'd say, at this point.
All right. I have no further questions. Thank you very much.
Thank you.
story on Hogan's sex tape not published?
I don't know.
Is it-
Oh,
It seems like it was ready to be published, what stopped?
I don't know.
Anything to that, or follow-up? Mr. Holden?
No, ma'am.
Mr. Holden? All right, and the next question is, did she or do you have you in the past or do you have an intimate relation with either Mr. Delario or Mr. Benton?
No.
Any follow-up?
No, ma'am.
Mr. Hartman?
No, you're right.
All right, thank you. Now we'll take a real comfort break. So how about that?
Thank you.